Hello and welcome to this vodcast on the English legal system with Dr. Ryan Murphy. Today what I wanted to talk to you about was a recent case update that's happened in the field of arbitration. So more particularly or more broadly that falls within alternative dispute resolution. And I wanted to talk to you about the case of S&S, which is a case of 2014, EWHC 7 FAM. So it's the Family Division of the High Court. It was a case on a breakup of a relationship, and the court was asked to enforce, or the court was asked more correctly to give weight to permit through a consent order a privately agreed arbitration on the split of assets. And the case is important. It was heard before Sir James Munby, who's the president of the Family Division of the High Court, and therefore some importance should be attached to that from the outset. And the reason that the case is important is because we've seen some really interesting developments, not only just within family law, but how that impacts upon the English legal system more generally in relation to how parties settle their disputes. Traditionally, there have been two routes to settle your family disputes. Firstly, you could enter into mediation. Mediation has seen a huge growth within the family law arena, in particular couples wishing to go through get certain family-related orders have now, most recently, been required to attend a mediation meeting, where they don't actually go through mediation, but they talk about the possibility of them mediating their disputes. So that's kind of traditional route one of resolving your family law disputes. Traditional route two has been through the formal court process, through litigation. And arbitration has had a very, very, very limited role within family law disputes until very recently. And the catalyst for this case, the catalyst which has prompted this opening up of family law disputes to arbitration, has been the development of the IFLA, the Institute for Family Law Arbitrations. Now that is an institution which is a not-for-profit organisation which has been created by the Chartered Institute of Arbitrators, the Family Lawyers Group called Resolution, and the Family Law Bar Association. So very high-profile institutions within the legal system have come together to create this IFLA. It has no statutory framework, has no statutory support. It's something that has developed due to the need in the market, the increased need in the market, not for mediation, but for arbitration in family law disputes. And many questions can be asked about that, and the textbook English legal system spotlight series goes in a little bit to talk about arbitration and mediation in family law disputes, so I'm not going to repeat that now. But what is very, very, very important about this case, S&S, is that the courts seem to be willing to foster and encourage the IFLA, the Institute of Family Law Arbitrators, in facilitating private law arbitrations in regards to family disputes. Now, the benefits of arbitration are well known and most commonly applied in the commercial sector. So in international commercial law has a very high incidence of arbitration agreements. But one of the key benefits of arbitration is confidentiality and privacy. It perhaps therefore comes as no surprise that the IFLA has been doing a lot of work with very, very wealthy couples who are splitting up. It would be damaging, or they do not want it known, the extent of their assets or how their assets have been split. So in S&S, I seem to recall that we were talking around assets, matrimonial assets, of about £1.5 million. So why did the IFLA set it up? Well, the IFLA was in part a reaction to the court's increased acceptance of private law agreements influencing how the court splits assets when couples break up. So there have been a developing case law on prenuptial agreements and the enforceability of prenuptial agreements. And the court has started to come around to the idea that, although with some reservations, they will approve and enforce prenuptial private agreements, consensually entered into by the parties before they were married. And it's therefore just an extension of that logic that when people split up, if they go through a binding arbitration, so if they choose to enter into an arbitration, the key word there is choose, then the court will not look in great detail at the arbitral award when it comes to issuing a consent order. So to put that slightly differently, the court is now heavily influenced by the findings of arbitration because the parties have entered into that arbitration willingly and consensually. The court does not see its role then to interfere with that private party choice. So when it comes to enforcing or making legally binding family law arbitrations, the court will be willing to do so. That's not to say that the court will take a completely standoffish approach. In many ways, the court's role is just similar to that it is in ordinary arbitration. The court becomes a supervisor, has a supervisory function for arbitration. As I say, no particular special statutory framework has been created to accommodate the IFLA, and therefore the Arbitration Act 1996, which again is discussed at great length in the textbook, will be of relevance here. So the kind of message that I want you to take away from this podcast is not actually about family law at all. It's not about prenuptial agreements or whether they're good as a matter of policy or bad as a matter of policy, how we should deal with couples when they split up. That would be for a different day and indeed a different module, one based on family law. What I want you to consider after listening to this brief podcast is what it tells us, the development of the IFLA and the court's response to a binding arbitration in S&S is, what is the future for arbitration within the English legal system? What is the future for ADR within the English legal system? And my feeling is that this signals a further encouragement by the formal court system that parties should and can, and the court will recognise and help and facilitate this in the orders it makes, the use of ADR. Therefore, we are likely to see similar schemes to the IFLA arising in different arenas, that we are likely to see the development of the IFLA, that we are likely to see increased recognition of IFLA, and particularly of the merits of arbitration in family law disputes. As I said previously, mediation has been the domineering and dominant force in terms of ADR, alternative dispute resolution, within family law disputes. The IFLA, and in particular the case that I've discussed, S&S, 2014 EWHC 7 of the Family Division, is an interesting development because it can only foster and encourage arbitration as a method of solving family law disputes. Hope you found this brief podcast useful. Keep looking at the website because more of these podcasts will become available as we have developments within the law. Thank you very much.